Supreme Court at work. And the Supreme Court has a regularly scheduled work time. They meet on the first Monday in October, and basically they go through about June. So as we take a quick look, there's the Supreme Court, and I want you to take a look at the calendar. So the calendar will give you an idea of what they do. The red days are argument days. Those are the days that the justices are actually hearing cases in the Supreme Court. The blue, as you can see, is a non-argument day, but probably a work day. They'll be there. The green is an important day. The green are conference days. Those are the days the justices come together, and they might have preliminary discussions about cases. They might decide to take cases or discuss ones that they have already heard. So when they start, it'll be the first Monday in October. They will hear cases, they will think about them, discuss them. Eventually, they will write opinions, and they will release them periodically all the way through June. So as you can see, you hear cases Monday through Thursday. You need at least 6 justices present to hear a case. Before oral arguments, the justices read the attorney briefs. So before you come in as an attorney, they already know all of your arguments, and they are going to be questioning you based on what you have written. The justices also read the amicus curiae briefs, also known as the friend of the court briefs. And those can be quite long and quite extensive in the detail. For example, a famous example of an amicus curiae brief was when the tobacco industry was being sued because they had a product which was legal in the United States, which came with a warning label, but still led to people dying by using that product. The alcohol industry filed amicus curiae briefs on behalf of the tobacco industry's case. And the alcohol industry, even though it was not under attack, looked and figured out pretty quickly, hey, if the tobacco industry loses these suits, we're probably next. We have a product that is legal, that comes with a warning label, but people have died from using it. So they are going to hire attorneys to try to support the side that they prefer. When it comes time for oral arguments, the amount of time is 1 hour. You get 30 minutes per side, and those 30 minutes are a set 30. They actually have lights that go off, and when the light turns red, you stop talking. At Friday conferences, the justices will discuss the cases, and they will see if they can reach an agreement. In order to reach a decision, all you need is a simple majority, 5 of the 9 justices. There are times where a justice may not participate. That is called recusal, where the judge may recuse himself or herself because they have a connection somehow to the case. For example, a famous one was Supreme Court Justice Stephen Breyer. His brother is on the California Court of Appeals, and when a case about medical marijuana came to the Supreme Court, well, it was Stephen Breyer's brother who had decided the case in California. So Stephen Breyer said, you know, I got a connection to my brother. It's probably not a good idea for me to hear this case. So he recused himself. The only person who can recuse a justice on the Supreme Court is the justice himself. Okay? So, again, all you need is a simple majority. In the event that there were 8 justices who heard a case and it finished 4-4, whatever the last Court of Appeals said stands, and it stays in effect in that area and that area only. So what types of opinions can we get? The written opinion, and there's only one that actually matters, it is called the opinion of the court, is legal arguments to the world and other judges also as to why the court saw things the way they did. So let's take a look at the types of opinions. You can start with the unanimous one, and these are not as common as they used to be. Historically, about 1/3 of opinions are unanimous, and this is where all 9 justices agree. It is a 9-0 vote, and they all said this was a no-brainer. More and more often, you will get what's called a majority opinion. And that means that the vote was either 5-4, 6-3, 7-2, or 8-1. It was not unanimous. When you get a majority opinion, you will have a decision. It's done, and you will have an opinion of the court that is written. When you get the majority or unanimous opinion, again, there will be this one opinion that matters. the other opinions that are written count somewhat in explaining things to the rest of the nation. For example, let's say it was a 5-4 decision and you're one of the 4 justices. You can write what is known as a dissenting opinion. The dissenting opinion many times is used to try to bring the case back to the Supreme Court at a later date. What winds up happening is the justices say, look, we think that this was a bad decision. Here's why we think it's a bad decision. And here's what we think you should do to try to challenge this again. It's kind of like a framework to try to get a case back to the Supreme Court, because a 5-4 against you could be a 5-4 in your favor if you can change one justice's mind. You also will get concurring opinions. And concurring opinions are when you say, yes, I agree with this decision, but I took a different route to get there. So the opinion of the court may focus on one piece, but the concurring opinion would come from a completely different angle. For example, a good example was when the Supreme Court heard the challenges to the Affordable Care Act. And that was a 5-4 decision. 4 of the justices who agreed with the decision felt that Congress had the power to enact the Affordable Care Act under their power to regulate commerce. 4 of the justices who disagreed with the decision and wrote dissenting opinions felt that the Congress exceeded its authority under the Constitution when it came to regulating interstate commerce. The only opinion, however, that mattered was the one written by the Chief Justice, the opinion of the court. And he felt the Affordable Care Act was constitutional under Congress's power to levy taxes. So he wrote an opinion about the constitutionality of the law based on Congress's power to tax. The other 8 justices all answered a different question, and that was about interstate commerce. But in the end, 1 + 4 said, yes, it is constitutional, and the law stood. So you can have majority, dissenting, concurring. Assigning of the opinions. This is actually a big deal. If the Chief Justice is in the majority, then the Chief Justice can either write the opinion himself or he chooses somebody to write it. If the Chief Justice is in the minority, whoever the most senior justice that's on that side will basically act as the Chief Justice. They can write the opinion themselves, or they can assign it to someone else. Now, notice I said senior, not oldest. This is based on years on the Supreme Court. The politics of opinion writing is actually a big issue here. You see, when it comes time to write the opinion, you want to make sure that people don't change their minds, or that you don't go too broad or not broad enough, depending on the case. So the Chief Justice is going to try to get what I call the right slant on the issue. He wants to frame it in a way that he's comfortable with. When you write that opinion, you got to be careful, though, because if you go too far, you can have a justice change their mind. And I'm going to give you a specific example of that in just a second. Actually, let's do it right now. The case is this one called Bowers versus Hardwick. This was back in the 1980s, and it was a Georgia sodomy case. It's going to sound like I'm telling a joke. I'm not. A guy walked out of a gay bar, and when he came out of the gay bar, there was an officer there. The officer ticketed him, saying that he had alcohol in his possession. He actually disputed that, saying he had left the alcohol on a ledge in a hallway, but the officer wrote him a ticket. The officer, he took the ticket and went about his business. The man who received the ticket, Hardwick, he wound up paying the ticket, but there was a glitch in the computer system that processed this, and the officer looked it up one day, and it said that Hardwick had not paid the ticket. In actuality, he had. The officer then went to the man's apartment, knocked on the door. Another man was there. He asked if he could come in. The man said yes, and he asked where Hardwick was, and he said he was down the hall. And the officer went, and the door was slightly ajar, and he peeked in, and there were 2 men engaged in homosexual activity. Well, in Georgia in the 1980s, consensual sodomy between 2 adults was a criminal act, and he was placed under arrest. This case will make its way all the way to the Supreme Court. And when it gets to the Supreme Court, they have a discussion about whether or not you should be allowed to engage in homosexual sex in the privacy of your home. And originally, Lewis Powell, one of the justices, was going to side with the idea that you should be allowed to do that in the privacy of your own home. So the original vote was a 5-4 vote to strike down the Georgia statute. However, once the opinion was written, you have to share the opinion with everybody in the room. And Lewis Powell, when he heard the opinion, said, that goes too far. I'm going to change my vote unless you change the way that opinion is written. The justice who had written the opinion refused to change it, and Powell changed his vote. He jumped ship. And so instead of striking down the Georgia statute that said sexual interactions between consenting adults in the privacy, homosexual actions in the privacy of their home was going to be unconstitutional. Oh, man, I'm messing that up. Okay, plain English. They didn't strike it down. So that law stayed on the books until I believe 2002 in another case called Lawrence versus Texas. So because of the way it was written, the justice, Lewis Powell in this case, changed his votes. Now, what else are you doing with these? If you have an 8-1 vote, you may try to push and get this to be a unanimous vote. Why? Because if it's unanimous, there's no real push to get it back to the court. So the one person who is willing to write a dissent, maybe you can change the opinion a bit to get them on board. And that pretty much solves the issue forever. Now, why do we do these? Why do the justices write these opinions, especially since there's only one that matters, and that's the opinion of the court? Well, one is for us, so that we, the people, know, A, what does the Constitution mean, and B, why did they say this? Where did they get this idea from? The next one is a very important phrase. It shows up on the AP exam all the time. It is called stare decisis. It means let the decision stand. The idea here is that you establish precedents for the future, and from that point on, everyone will look at that precedent and they will leave it and follow it. For example, in 1973, the Supreme Court ruled that a woman had a right to an abortion in the case of Roe v. Wade. Since that point, we have recognized that a woman in the first trimester has a right to an abortion under Roe v. Wade. It does not mean that the case or the topic will be ignored forever, but a court can't simply turn around today and say, no, abortion is wrong and we're going to outlaw it in our state. They're not allowed to do that because the precedent has been established. And if a court ruled differently or a legislature makes a law that says you cannot have an abortion, then the court will strike that down because we have established in Roe v. Wade that a woman has that right. What else goes on here? Well, you're the court, you may want to drop a hint to Congress or the state or the president that they should take certain actions. As a matter of fact, that happened with the Voting Rights Act of 1965. There were challenges that were brought up in the early 2000s to the Supreme Court about the Voting Rights Act. And one of the things the Voting Rights Act said is that if you were a state with a history of discrimination, mainly states in the Deep South, then if you were going to change anything about voting, you had to submit a plan to the Justice Department to say, here are the changes we plan on making. And the cases were brought to the Supreme Court saying, you know, just because you were discriminatory in the 1800s or even in the 1900s doesn't mean it's the same today. And the court said, you know, that's not a bad point. Congress, President, maybe you guys want to do something about this because if we take this case, you know, we may have to change it. And nothing happened. The Congress didn't make law and the President couldn't. So the Supreme Court struck down Section 5 of the Voting Rights Act of 65, and today you no longer have to submit a plan for changes to the Justice Department. So they may try to give you an opportunity to make some changes. Now, moving towards the end, the possibility of evading court decisions. Yeah, the Supreme Court is the highest court in the land, but it's not a dictatorship. The biggest single check on the Supreme Court is our ability to amend the Constitution. The court cannot strike down something as unconstitutional if it is in the Constitution. So once it's added, they have to base their decisions on that. Second, when a decision is made, it's basically, and you can see the word, remanded. It's given back to the lower courts to carry out the Supreme Court's decision. The lower courts do have a certain amount of leeway in doing this, and honestly, they're probably not going to be checked all that closely. The third one, and this has happened historically, the executive branch can simply say, that's nice, we're going to ignore you. That was the Trail of Tears where Andrew Jackson said, John Marshall has made his decision, now let's see him enforce it, and that dealt with the removal of the Native Americans from their lands. Yeah, it's fine for the Supreme Court to say things, but let's remember that the president and the executive branch, it is their duty to enforce the law. So the Supreme Court can interpret what they want, but if the executive branch chooses not to enforce it, there's not much the Supreme Court could do. Let's see, 9 people on the Supreme Court, Commander-in-Chief of the Armed Forces of the United States. I think I know who's going to win that battle. Next one, state and local governments may simply not carry it out. You know, there's a phrase here, and I think it does matter. The Constitution may be what the Supreme Court says it is, but a Supreme Court opinion is what a trial judge or a policeman or a school board or a city council says it is. You can say what you want in Washington, but in the end, local areas will decide what those words meant to them, and they will interpret them. So let us finish this lesson taking a look at the justices, and I'm going to tell you that today is actually January 1st, 2015, as I am recording this. Yes, this is how I'm spending my New Year's Day, at least part of it. And on this day, I'm going to give you the ages of these people, because some of them will actually have birthdays in a little while. We are going to start with John Roberts. John Roberts is the Chief Justice of the United States. There he is. And as I record this, John Roberts is 60 years of age. He will turn 61 very shortly, but John Roberts is our Chief Justice. John Roberts is, and you're going to see we have 4 strong conservatives, 1 moderate conservative, and 4 strong liberals. Our next person up is Anton Scalia. Anton Scalia was appointed by Ronald Reagan. Anton Scalia is 78 years of age. By the time President Obama finishes his term as president, Anton Scalia will be about 80. This again is why I've said to you in the past that whoever the next president is, there's a real strong possibility that they will have some vacancies on the court. Next we have Clarence Thomas. Clarence Thomas was appointed by George H.W. Bush. Clarence Thomas is kind of young on the court, at least on the conservative side right now. He's 67 years of age. Clarence Thomas is a very strong conservative and almost always votes with Anton Scalia. They tend to form a voting bloc on the court. And when you think that there's only 9 people on the court and it only takes 5 to win a case, having voting blocs does matter. Our last strong conservative, appointed by George W. Bush, along with John Roberts, Chief Justice, is Samuel Alito. Samuel Alito just turned 65, and he will be, well, he turned 65, he will be 60, no, he's 64, he's going to be 65 in April. My bad. He will be 65. So there is Samuel Alito. Moving on to the moderate conservative, you will see Anthony Kennedy. No, he is not related to the Kennedys who were president and attorney general and all of that. Okay, he was appointed by Ronald Reagan. Just think about how long ago that was. Anthony Kennedy is also 78 years of age. Moving on to our liberals, we have Ruth Bader Ginsburg, who was appointed by Bill Clinton. She is up there in the years right now. She is 81. Many thought that she would have stepped down, and she has not. With the Republicans taking control of the Senate, it's very unlikely that she will in the near future decide to step down. She has already had 2 bouts of cancer, and It's kind of amazing that she is still with us. She just had something happen recently. She had to miss a couple of days, but she loves being on the court, and she basically has said, "I'm not going anywhere." She is currently 81 years of age. Stephen Breyer was also put on the court by Bill Clinton. Stephen Breyer is 74 years of age, and getting near the end, we have two people who were put on the court by President Obama. We have Sonia Sotomayor. Sonia Sotomayor, and I just point this out because of who I am, she is actually a type 1 diabetic. I believe she is the first diabetic on the court. She was put on the court, as I said, by President Obama, and she is 60 years of age. And then our last person on the court is Elena Kagan. Elena Kagan was a former solicitor, United States Solicitor General. That meant that she actually represented the United States in the Supreme Court. So anytime it was like U.S. versus, she was the United States. She was put on the court by President Obama. And by the way, you might notice the approval vote here was 63-37. This is where we started to get pretty partisan in the Senate. It's gotten bad, as we've spoken about. She is young for the court. She is 54 years of age. She's just a little older than me, so she will probably be on the court for quite a while. So there's your voting blocks: 4 conservatives, 1 moderate conservative, 3 liberals, and we will have 1, 2, 3 people who will be in their 80s as the next president gets sworn in. So that could make a big difference in the makeup of the court. As time goes on, we will see. All right, that brings this lecture to an end.